Matt Day here with Parsons Graham and Day, and want to talk about splitting up retirement assets during a divorce. Now, as you're aware, when a divorce occurs, it's the splitting up of the family unit, including assets that were gained, purchased, otherwise acquired during the marriage, with limited exceptions. So, when we look at retirement assets, IRAs, 401ks, even pension plans, we need to look at when did we get that asset, what was contributed during the marriage, okay? The marital portion of that is going to be subject to a division. That doesn't mean that every single retirement account is going to be divided, okay? Sometimes there are offsets that sort of save the division of a retirement asset. So for instance, if there are two parties and each of them has an IRA, and the IRAs are equal or roughly equal, sometimes you avoid the division of the IRAs because there's an offsetting asset that's going to the other party and vice versa. The main thing is that IRAs, retirement accounts, they're assets not unlike houses, not unlike vehicles. If they're acquired during the marriage or if proceeds are put into them during the marriage, then that becomes marital, and we've got to look at whether or not that needs to be divided and how. And remember, the division doesn't necessarily mean equal 50-50. It is equitable, that which is fair in the view of the court. A lot of this gets handled through negotiation. But to answer the question, does it get divided? Yes. How does it get divided? Very fact-specific analysis goes into how it's going to be divided in terms of percentages and whether or not it's going to be divided at all.
The purpose of this video is to be informative and not to provide legal advice. For legal advice, call a law firm and speak to an attorney about your particular case. None of the information provided in here is meant to establish the attorney-client relationship between Parsons Graham Day and anyone watching this video.